Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. Sorry, I'm still getting everything set up now. How's it going, guys? Welcome to the week. Hope you had a nice weekend. I said getting my chat windows set up, getting this damn stream set up. Oh my gosh. How about that football, guys? How about that Super Bowl or whatever? Did you guys watch the Super Bowl? I watched a lot of it, but not all of it. I missed some. It was fun. I didn't really care who did anything, although I was happy that Taylor Swift won the Super Bowl. That was my main goal of this weekend. My main goal of this weekend was somebody named Taylor Swift would win the Super Bowl, and that did happen. So I'm proud to say my prediction was correct, which means the Kansas City Chiefs won. Spoiler alert, if you didn't know, the Chiefs won the Super Bowl. Hope you're happy. Hope you're happy. Oh my gosh. Let's see. I am. Oh my. Oh, I can hear myself. So, yeah, I don't know about you guys. I literally don't care in the slightest about the NFL, any particular team or anything like that. I don't have anything. What is, okay. All right. I don't have any problem with conceptually the sport of football or any other sports or watching them. I do like watching people at the top of whatever activity they're doing. And, they're these top athletes running around, touching each other. It's very erotic, very, very sensual. And you got to respect that at least. So I did have fun doing that. We had to step away from the game for a little bit because we had a family member who had a medical procedure and they were recovering and all that stuff. So we were able to go visit them. We missed part of the game, but that's okay. We did see the halftime show. I actually kind of liked it. I saw some criticisms like Usher didn't do a good job. And I was like, well, I mean, it is Usher. Seemed to do fine for Usher. I didn't expect some landmark performance. But it was, it was fine. They got Ludacris and Lil Jon out for yeah. And that was happy. I was right there. I was happy. That was the main thing for the halftime show for me. I did want Taylor Swift to come out onto the onto the stage for the halftime show, mainly because I'd bet on it. Not like a real bet, like friendly bet with some friends. But anyway, that's all said and done. That's done. And after watching it, I still don't care. It's not my thing. I know a lot of people get way into it, and that's cool, but it's not for me. All right, guys. So here's what we're doing tonight. We have the oral arguments to finish for Trump and his disqualification case in Colorado that is now before the United States Supreme Court. This was argued on the 8th. This is the third show we're doing on it, and it will be the last show we're doing on it. We have 30 minutes of that audio left, roughly, and I do want to finish it. It's the second half. It's the second half of the, the Colorado side of the argument. It's the second half of their oral argument. Trump's side went first. They gave their roughly an hour of oral argument. And now the state of Colorado is going to do oral for an hour, which is not new for Colorado or surprising for them at all. They're very used to it. So that'll work out well for them. And we'll see. I mean, my position on this has not changed. I haven't seen anything at all in in either argument to influence my opinion much. What I see is Colorado's argument is that they should be able to disqualify a presidential candidate from a ballot because they should. And Trump's side of the argument effectively making Trump's side effectively making the argument that if a state is able to remove a candidate it's a huge problem. And so they can't do that unless Congress lays out a procedure by which it can be done. And that follows the text of the amendment. It follows the logic of the Reconstruction Amendments in general, because they're taking away state power and increasing federal power. It follows the plain reading of all of it, and it makes the most sense. They're also, of course, their argument is that the president doesn't qualify under either of the lists, which I also agree with, and I think is a really strong argument, but they're not making it as a strong argument. So that's kind of a summary. We're going to do that. That won't take the whole show. Fani Willis and Nathan Wade are about to have a hearing, I think on Thursday of this week, to see if she can account for the allegations that she's in an improper relationship with Nathan Wade, the special prosecutor. Remember, Fani Willis is the district attorney of Fulton County, Georgia. She hired Nathan Wade, the special prosecutor, to go after Trump for election interference crimes in Georgia under Georgia law. And that case has been going. And now one of Trump's co-defendants has raised ethical concerns with Fani Willis. She's the one who looks like a loaf of bread. And she has allegedly been banging and gallivanting around the world with Nathan Wade, who's a special prosecutor. Now, the problem with this isn't necessarily that they have some sort of relationship. The problem is that relationship could cause a couple things. One, undue influence on the case, because the special prosecutor is there to have some independent power, be removed from the political process a little bit. The other problem with that is that she signs the paychecks for the special prosecutor. She determines how much he gets paid, and the rate by which he bills for the hours. So with that, there may be a conflict of interest if she's paying this guy and then he's, flying her to different cities, taking her on cruises. I can't imagine them actually engaged in like physical relational stuff. And the reason I can't imagine it is because Fani Willis is hideous. She's hideous. Why am I pale? It's the middle of winter, mainly. I'm very light-skinned in general, especially in wintertime. And I also have these bright-ass LEDs shining on my face, so there's not as many shadows. And that creates, this sort of effect where it gets lighter wherever the light hits me. So that's what you're seeing a lot of. All right. That's the next thing. And then finally, Trump's immunity petition is going before the Supreme Court. He is asking the Supreme Court to grant him some level of criminal immunity. And they filed their petition, and the Supreme Court will have to decide on whether or not to take it. The D.C. Circuit Court of Appeals did not say that the president has any sort of criminal immunity, and the D.C. Circuit Court of Appeals was petitioned for an en banc review, which means they would all sit and listen. They declined. They just upheld the decision of the 3-judge panel. So with that, he has one choice, and that's to go to the Supreme Court. Anyone making a big deal out of the lower court rulings on this should really slow their roll in either direction, because there is no precedent for this. There is no jurisprudence around presidential criminal immunity. The only thing we've really got is presidential civil immunity, and then commentary about what criminal immunity might look like, if it's even valid. And notably, Brett Kavanaugh has some commentary out there from an older paper law review article, something like that, that might make a decision challenging for him to render, but not really, because just because he has an opinion at a time, even through a law review article, just because he has an opinion at one particular time about an issue doesn't mean that he won't be swayed otherwise with other research, with other considerations, with more fact-specific questions and stuff like that. So anyone who's looking at this going, well, DC Circuit Court didn't give him immunity. Well, they don't have a way to. There's nothing that says the president gets criminal immunity. It's not directly in the Constitution. Even the civil immunity is inferred by the balance of powers in the Constitution. So it just depends on if the Supreme Court wants to go ahead and extend that type of balance of powers analysis into criminal law. And if they buy the no one is above the law argument, which is a stupid argument. a very stupid argument, and no one should use it. If you use the above the law argument in regards to the president and criminal matters or civil matters, what you should do is take a baseball bat, shove nails through it, and then shove it down your throat. Well, that was delicious. All right. Hope you're doing okay, Rackets. I'm doing great, actually. I've had some stressful days, but on balance, things are good. Life is good and busy. Kids are healthy. Family's healthy. Wife's healthy. Like I said, we had a family member with a medical procedure, but it wasn't like a bad one. It went really well, so that was very encouraging. So all this has been pretty good. Pretty good so far. So, okay. Nexus, that's weird, but I'm with it. All right, let's hit a couple super chats. I need to get whiskey. That's what I need to do. I have whiskey. I just need a clean glass. It's been a while. Oh, no. Damn it. I'm doing too much karaoke lately because it's been a while since I use these Norland glasses. Actually, I broke one of them, which was depressing. I broke one. Someone dropped one. It wasn't me. I'm preggo, aren't I? Yes, I'm pregnant. That's true. That is true. So, what happened to the candle? What candle? What the hell? I'm always, am I related to Zia? No. Not talking about her procedure this morning. No. Karaoke bar every night. There aren't karaoke bars around here that have them even every night of the week. It's really weird. Most of it is in my house. All right, delicious. So here we go. Have I lost weight? I look skinnier. Yes, but a long time ago. Like I've been this same weight for several weeks now. Okay, we're gonna get into these super chats. Hello, my friend, my fellow N-words says, I'm glad I caught you. Gonna head to sleep and touch myself to your voice. Hashtag no homo. As long as you say hashtag no homo, that works. Jim Satala says, hope you're feeling better. I am. I hear that traveling to Florida to drink a few bottles of Blanton's with your buddy Jim can be a great way to reduce stress. That sounds phenomenal. Jim, I may take you up on that sometime soon. I don't know when our next trip down to Florida is, but I really want to go. I hate being in Minnesota in the winter. It's cold. It's miserable. It's not even cold right now. It's just kind of damp and just warm enough for it not to freeze, which is nice for driving, but all the days are foggy and gray. Malcarian says, Nick, Camelot is less than 1,000 away from 110K. Almost got 2 races funded. Can we get a shout out to get him across the finish line? Yes, make sure you check out. Make sure you check out Camelot. It's a GoFundMe, right? His GoFundMe, Ethan Van Sciver is helping him out with that. They've raised over $100,000, I think over $110,000 now, because he's doing NASCAR races this year. And I believe Ethan has designed a Cyberfrog car to sponsor the car, and then that'll be the car he's racing, which sounds fucking awesome. I've got to talk to Camelot. I've barely even talked to him in a couple weeks. I barely talked to anybody. Again, my life gets really, really busy unpredictably sometimes, and it's been one of those times. So I've been out of the loop on a lot of stuff. Trying to get back into it and make sure I like keep up with friends and family members, because even them, not talking to them either. Who would want to talk to family? Low Watermark says Cody's crowdfunding campaign only has 3 hours left to fund his NASCAR race entries. Well, I guess let's pull it up. Let's pull it up real quick because, Cody's my boy. I wish I could have had him on for this or been on with him. Here we go. Cyberfrog Heartsick Deluxe plus race car. So this is the Indiegogo campaign. I'm going to share it in the chats so that people can see it. We'll share it in all of the chats, YouTube, Rumble, and locals. And here we go. And I got one more time. Here you go. Make sure. Who the fuck is Aaron Kairos? Distracted me, Richie. So here we go. This is the Cyberfrog Heartsick Deluxe Plus race car. Heartsick Deluxe Edition. Let's race with Cyberfrog mini cars. Oh, wait. So he's having a seizure. So Cody signed diecast cars, $100. Very cool. What else? What do we do? You buy EVS a pie, Cyberfrog Heartsick Deluxe comic, mini race car, buy 5 pies, 4 Cyberfrog race cars. You can get all this stuff. 10 Cyberfrog race cars. Add your name to the car. Oh, that sounds cool. So anyway, here's the campaign. Guys, check it out. Cody Camelot is racing NASCAR. And if you don't know what that means that NASCAR is you have to pay. You have to pay to race NASCAR. And it's not cheap. It's not cheap. So we'll have to check that out. He's got a couple hours left. So that's cool stuff. All right. Matrix says Jim Satala. Okay, but Ricada said it was a defamation lawsuit and it's not. Clear he never read the brief. Matrix. Hi, pal. I know the issue you're talking about, and I'm well aware of my grade as I monitor all lawsuit activities. Actually, I didn't know anything about this at all, but apparently somebody out there was miffed that I was talking about Gina Carano's lawsuit as a defamation lawsuit and said it was clear that I did not read the brief. It was clear that I didn't read the brief because I said I haven't read anything about it at all. And someone asked me specifically about the quote unquote allegedly defamatory statements, which I was responding to. I've not read the brief, never claimed to read the brief. I think said at that time, I didn't read the brief. Don't give a shit about Gina Carano's lawsuit unless she wins. I just saw that she tweeted about it. Apparently Elon Musk or something is funding it. It's interesting. Someone asked me about the statements, said they were defamatory. I looked at them, said, oh, there's problems with them being defamatory. But yeah, I don't know the legal issues at all. Didn't claim to. Might read it eventually, but it's going to be covered by everybody because that's how this sector works. And that's just great, which is cool. But yeah, no, it's, that's not super interesting to me other than the announcement of it and everybody freaking out about it. We might check it out. I don't know. Like I said, I got a bunch of stuff to look into and catch up on. For now, though, let's go ahead and get into this final 30 minutes of the oral argument. You think it's fun to see someone finally go after Disney? Well, yeah, that'd be great. I hope they win. It'd be funny. Look, defamation, no defamation, it doesn't matter what it is. What they do to people, what these corporations are doing to people on allegations or on this wrong think or DEI bullshit, it's all garbage, right? It's terrible for the economy. It's terrible for speech. It's terrible for all these things. So yeah, go after them, win. But if you go after it from a defamation standpoint, that's going to be a problem with those statements, which is what I was saying, because that's what I was asked. But anyway, here we go. Anna's wedding cake dispute. I have no idea what that's about. Why is everyone turning their back on you? Is everybody turning their back on me? Holy shit, that would be terrible. Maybe because it's an invitation, if you know what I mean. I have no idea. I don't know. Guys, I have to reiterate how little I am paying attention to much of anything right now other than specific show topics that I have, because I just am fucking swamped with life, which is good, but also busy. Here we go. Oral arguments, part 3.
But it seems unlikely.
Justice Sotomayor?
There's two sides to the other side's position. The first is that it's not self-executing. I want to put that aside.
Yeah, you do.
Deal with if we were to hold that states don't have the right to enforce or create a cause of action in this situation.
Of course they don't.
They want the flip to say that no, but even Congress can't do it because they need implementing legislation. Address that argument. Because assume we rule that states don't have it, what would you have us say for the other side of the argument? One of my colleagues says you need, or what
Get it out,
not-
Sonia.
not then Chief Justice, but Circuit Court Justice Chase said, which is that somehow you need implementing legislation like the 1870 Act. You seem to say that's not true because they could decide not to seat seat a candidate, etc. So,
Oh my God. Ah. Ladies and gentlemen, Justice Sonia Sotomayor. It's like fucking listening to Slowbro Rodriguez go through it. Hello, it would be nice if you go ahead and explain how Congress cannot enforce the 14th Amendment unless he make an act, you know. Justice Judge would the circuit court judge would like to make a fine argument. Jesus Christ, talk, spit it out. Oh my God. Carson 87 says, seeing you going live on YouTube got my sexy Slavic super snakes excited. Tucker Carlson just stated that the CIA and NSA have been preventing him from going to interview Putin for the last 3 years by leaking it to the MSM. Cool. Yeah, go get him, Tucker. All right, back to this. She is the fucking worst.
I don't know that legislation is necessary.
And certainly there are historical examples of members of Congress under Congress's Article 1 power to judge the qualifications of its members, of members of Congress refusing to seat ineligible candidates under Section 3 who have won election. In the context of the presidency, I think it would create a number of really difficult issues if the court says there's no procedure for determining President Trump's eligibility until after the election. And then what happens when members of Congress on January 6th, when they count the electoral votes, say we're not going to count electoral votes cast for President Trump because he's disqualified under Section 3 under the Electoral Count Reform Act. A number of the amicus briefs, such as those of Professor Ginsburg, Hassan, and Foley, have made the point that that is kind of a disenfranchisement and constitutional crisis in the making, and is all the more reason to address those issues now in a judicial process on a full evidentiary record so that everybody can have certainty on those issues before they go to the polls.
No, actually, there's a couple. There are basic problems here. All right. Basic problems. One, there is a process by which a disqualified candidate's electoral votes are remedied and rectified. And that process is laid out in the Constitution. And it is the process by which a candidate does not receive a sufficient number of electoral votes. And then they goes eventually to the House of Representatives for a vote. There you go. They select a president. They have that. So if the winning president with enough electoral votes is disqualified, so those votes aren't read, so the other person doesn't have sufficient electoral votes to win the presidency, it goes through the process. That's one way. The other way is he's like, well, I mean, if there's no law, then that's a constitutional crisis in the making. All right, make a law, not a judicial ruling that states can just independently, or Congress can independently disqualify a president absent the process. The other thing they could do is always impeach. They can always impeach. But this whole thing is like, well, they can cure the disqualification after inauguration. I mean, where is the disqualification? That's the problem. Again, back in the 1860s, following the Civil War, they knew who they were disqualifying. I think there was an act disqualifying them by name because the Congress created a law about it. But even if it wasn't created by name, it was obvious who had done these things. It was obvious who had insurrected at that time. Very clear instruction, a clear list of people who qualified for those things. Since then, we haven't had that. This isn't even addressing the other problem of is the president even included in this? No, not by the language. But all of this stuff is not a constitutional crisis. It's easily resolvable and already has existing processes to deal with it. And the ultimate answer is still Congress could just make a law for the process if they think it's going to be a crisis. It hasn't been a crisis ever.
Justice Kagan?
Mr. Murray, you relied on the state's extensive powers under the Electors Clause. You talked about the states having a role in enacting, typical ballot access provisions. I guess, it strikes me that we've put some limits on that. And I'll just give you Anderson versus Celebrezzi as an example of that, where we said, in fact, states are limited in who they can take off a ballot. And that was a case about minor party candidates. But the reason was that one state's decision to take a candidate off the ballot affects everybody else's rights. And we talked about the pervasive national interest in the selection of candidates for national office. We talked about how an individual state's decision would have an impact beyond its own borders. So
this is Elena Kagan, who really is generally the best liberal justice right now. She was only brought in to uphold Obamacare. That was her entire purpose. But she's pretty reasonable. She's got decent questions. She doesn't talk like a fucking idiot like Sotomayor. In this case, Ketanji Brown Jackson has been phenomenal on the liberal side, but Kagan's not bad. She's thoughtful. And right here, she's grilling him. How the fuck do you get around the fact that one state deciding who's a presidential candidate messes up every other state horrendously?
So if that goes for minor political party candidates, why doesn't it go a fortiori for the situation in this case?
Well, certainly constitutional principles like Section 3 apply to everybody, but in Celebrezzi, the issue there was a First Amendment question. And certainly there's no doubt that states' exercise of their power under Article 2 is constrained by First Amendment principles. And in that case, the state law deadlines for when a minor party candidate got on the ballot just came too soon to be reactive to what major parties had done, and therefore risk disenfranchising people who were disillusioned with who the major parties had picked. And it raised First Amendment problems. Here, there's no real First Amendment problem, and a state is just trying to enforce an existing.
Whoa. No First Amendment problem. You are clearly within First Amendment territory here because Colorado has decided that Trump incited an insurrection, literal First Amendment activity, unless we go ahead and, get outside of the protected First Amendment speech, which would be tests for incitement, which he doesn't pass, has never been charged with, and has never been convicted of, and not even successfully impeached on. So yes, you're dealing in this case with quintessential protected First Amendment activity, and a state determining that First Amendment activity amounts to a criminal act without a prosecution. Yeah, you are in First Amendment territory. What the fuck are you talking about? Guys, people are idiots. James Gardner says, disloyal shyster. You should drive the Cyberfrog car and crash it. It's only fair. Just kidding. Go Kumalot. That'd be fun. I've never driven a NASCAR car. Camelot says it's way different than regular cars. Like, it's just torque and horsepower, and it's it's easy to say, oh, they just turn left. But apparently, like, you're turning left like 170 miles an hour. If you screw up at all, you die. It's wild.
Qualification that's baked into our constitutional fabric.
Yeah, I guess, it did come up in the First Amendment, but there's a broader principle there, and it's a broader principle about who has power over certain things. And
Kagan, it's also a First Amendment issue in this case, but keep going.
Our federal system, and, within our federal system, states have great power over many different areas, but that there's some broader principle about that there are certain national questions state where states are not the repository of authority. And I took a lot, First Amendment, not First Amendment, a lot of Anderson's reasoning is really about that. Like, what's a state doing deciding who gets to, who other citizens get to vote for president?
Exactly.
Colorado is not deciding who other states get to vote for
Yes,
president.
they are.
It's deciding how to assign its own electors under its Article 2 power. And the Constitution grants them that
Well,
broad
but the
power
effect
as-
of that is obvious, yes?
No, Your Honor, because different states can
The effect of that is obvious. If a sufficiently sized state bans a presidential candidate from the ballot, then they decide for the entire nation who they can vote for. Because at some point, there is a tipping point of not being able to win the electoral college vote. So yeah, they are. They all need this, and they all have the power to do it. And in the same way that the Supreme Court came to the conclusion on, we'll take this to a way different area for an analogy. The Supreme Court, when it removed racism as a primary factor in college admissions, they said if race is a determining factor in any case, then it is the determining factor in every case. Because when you come down to it, if you can be exactly qualified, two candidates can be exactly qualified in every single area, and the only place that they're not qualified is race, and that becomes a determining factor, then it's the only determining factor that matters, because it's the one immutable characteristic the candidate can't control. And so if they are in all other areas equal to another candidate, and one candidate wins and one candidate loses because of race, then race is outcome determinative factor there. In this case, that's what it is. If you have every electoral vote you need except for Colorado, and it is the deciding state for the election, and they've removed Trump, then they've removed every electoral vote he had otherwise won. And that's what she's asking. Isn't it obvious? Yes, it's obvious. He tries to dodge that, but you can't get around the fact that that is what it is. It is what it is. Casey, aka Snake Plush Kitten, says, Nick, you know the constitutional rights and protections only apply when it's convenient for the Democrats. I do. I know that. Kylus Rex 38 says, Mr. No Chat, ever seen John Ward on YouTube? His most recent podcast, CC3, makes a very strong argument that Tucker's CIA worth watching if short on time. 20-minute mark, worth dropping $20 to acknowledge. Okay, so John Ward on YouTube, the CC3 podcast, and that Tucker is CIA. Okay, so he claims that Tucker Carlson is CIA. I don't know, maybe I've never heard of him, but maybe it'd be good. Me 04120 says, Sonia also getting an F tier ranking. Rackets doesn't have to be lonely now. I never am. But it's good that me and Sonia are in the F squad. Casey, oh wait, I read that one. All right, here we go. Back to it.
Have different procedures. Some states may allow insurrectionists to be on the ballot. They may say, we're not looking past the papers. We're not going to look into federal constitutional questions. It's the sort of this, even in this election cycle, there are candidates who are on the ballot in some states, even though they're not natural born citizens, and off the ballot in other states. And that's just a function of states' power to enforce, to preserve their own electors and avoid disenfranchisement of their own citizens.
Thank you.
That's not actually the case, though. Like, well, a state could have an insurrectionist on the ballot, but why? Why? This is the trap question, by the way. Put some sort of visual up for this. No, there is none. The visual is this, dude. Here you go. It's just a web page. It's just an audio file from the Supreme Court. That's it. There's nothing to put up, unfortunately. You just have to put up with looking at me, which sorry. I could start slow dancing and pulling my shirt down or something. But the trick question, or the trap question here is, wait, states can have insurrectionists on the ballot. And he says, well, yeah. It's like, well, what happens if they get elected and they're disqualified? Well, they'd have to be removed. Well, wait, what? So how's the disqualification determination being made in the first place? And why would they, if they have the disqualified insurrectionist candidate on their ballot because they don't look beyond the papers or whatever, you already said that was a problem with coming up with a disqualification method that happens after the election, or a requalification method that happens after the election and before inauguration. You said that was a problem 2 seconds ago. How is it not a problem now? Oh, is it because it's convenient for your argument? Oh, yeah, that's it. That's it, isn't it? Kylus Rex 38 says, White hat before everyone freaks out, but I promise definitely worth watching the whole thing. No one should freak out about someone asserting that a major broadcaster who seems to have interesting takes might be CIA or former CIA or anything like that. I mean, Julia Childs was a fucking British special agent. No one should be surprised by any of this shit anymore. It's been going on forever. And it's almost like government's getting special agents into marketing and messaging might have benefits for the state.
Justice Gorsuch?
Haven't had a chance to talk about the officer point, and I just want to give you an opportunity to do that. Mr. Mitchell makes the argument that, particularly in the commissions clause, for example, all officers are to be commissioned by the president. Seems to be all-encompassing, that language. And I'm curious your response to that. And along the way, if you would, I poked a little bit at the difference between office and officer in the earlier discussion, you may recall. But I think one point your friends on the other side would make is, well, that's just how the Constitution uses those terms. So, for example, we know that the president pro tem of the Senate and the Speaker of the House are officers of the United States because the Constitution says they are. But we also know that they don't hold an office under the United States because of the incompatibility clause that says they can't. So maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer, not prepositions, nouns, a distinction. But maybe that's exactly how it works. Thoughts?
Well, I'd start with the idea that the meaning of
How was
officer
that?
in the 1780s was the same meaning that it has today, which is a person who holds an office. And certainly in particular
No, you dumb motherfucker. That is not the same meaning today or back then. An officer is not someone who holds an office.
context, like the commissions clause, it appears that that's referring, that is referring to a narrower class of officers, because we know that there are.
Except it says all.
Well, we know that there are classes of officers, like the president pro tem, who don't get their commissions from the president.
Well, that's because the Constitution elsewhere says that.
We know that the appointments clause refers to a class of officers.
Just steamroll that argument there. Like, ugh. So that's because the Constitution says that. We know that. Chicks Can't Fly says, take a shot. I love you, bro. I won't take a shot for $5, but I'll take a sip off of this lovely drink. Thank you.
Officers who get their appointment from the Constitution itself, rather than from presidential appointment. People who get their commissions from the president himself are not commissioned by the president. And so if you read the appointments clause in line with the commissions clause, then the commissions clause is really talking about the president's power. If one needs a commission, it's the president who grants it. But I think it's important to bring us back to Section 3 in particular, because that was 80 years.
Before we get to that, though, just the distinction between office and officer. Do you agree that the Constitution does make that distinction?
No. Officers all need a commission under the United States by the president. That's commissions clause. Holds office is a greater class than officers. That is someone who holds office under the United States. And not all of them are commissioned. Which tells you something pretty damn specific. Anyway, God, it's so fucking frustrating to listen to this shit. Look, this guy's got a really hard job. Colorado made a really fucking stupid decision. They made a really stupid decision to kick Trump off the ballot. They did. And now he's got to try and defend it. And he doesn't have a good argument. He doesn't have a great position to defend. He doesn't have a good case. He doesn't have the law on his side. He doesn't have anything to point to other than, well, they have to be able to. He didn't have a logical argument to make, even just like a common sense, maybe they could do this or that. No, he's got nothing. No public policy reason why a state should be able to remove a president. None of the arguments, none of the routes that you would tend to get to or utilize to make your case are available to this guy. None. And he's all the way at the Supreme Court of the United States trying to argue it. He looks like just a fucking fool. Tara Rayner says, it's funny how annoyed with Miller Gorsuch is. He clerked for both Gorsuch and Kagan, or was it Sotomayor, Lamau? I don't know who it was, but I did hear he clerked for them. But yeah, so challenge him, go after him.
Particularly with respect to the Speaker and President pro tem.
The Constitution makes that distinction, but at least in Section 3, an officer of the United States is a person who swears an oath and holds an office. Now, the President pro tem and the Speaker of the House, they don't swear a constitutional oath in that capacity. They swear a constitutional oath if they are a senator or representative in Congress in that separate non-official capacity. But I think that
You agree they are officers who don't hold an office?
They're officers who may hold an office but don't swear an oath under Article 6 in that official capacity.
Well, how can they hold an office under the incompatibility clause? It says they can't.
Well, I think that's a fair point, and I think that
I think that's a fair point. There was a no-win situation for this guy. He can't make this argument because look at what he just said. Well, they're officers, but they don't swear an oath. So if it says all officers, and then it specifies who swear the oath, does that exclude officers who are officers but don't swear an oath? And then you get into the questioning the president's oath, which is different than the other oaths that are mentioned. All of this has issues and concerns for it. And just because we haven't had too many situations that are like that, that'll fit the scenario they want to talk about, doesn't mean that they're not really huge problems for the argument, because they're still potentially possible.
that may be an exception to the general rule. And one might consider them perhaps officers of the House and Senate because they are appointed by those bodies and preside over those bodies.
Well, the Constitution says they're officers of the United States. So there are some.
Constitution just says so. You fucking dummy. Constitution says so. That's what it's right there. They're just officers of the United States.
Some instances when you have an officer, but not an office.
Those may be an exceptional circumstance, but I would.
Thank you.
Justice Kavanaugh?
The concerns of some question have been how the states having such power over a national office. Other questions about the different states having different standards of proof. And they seem underscored by this case, at least the dissenting opinion below. Justice Samore said, I've been involved, quote, I've been involved in the justice system for 33 years now, and what took place here doesn't resemble anything I've seen in a courtroom.
So he's citing a dissenting opinion from the Colorado Supreme Court who said that this wasn't anything. This doesn't look like anything they've seen in 33 years as judge. Nothing like it. Nothing like analysis and application of law happened here. And that's crazy to think about. Cheesy Tyrion says, to help grow your channel, you should show gaming footage for the Zoomers, pole vaulting for cultured men, or puppy videos, because everyone has HDHD today. But serious, it wouldn't hurt. Actually, it would in a weird way. I'm not focused on growing this YouTube channel. If I was, I wouldn't be doing this Rumble flip with no shorter videos or clipped up stuff or anything to promote the algorithm. I haven't been doing that for a while, because I'm not focusing on growing the YouTube channel itself. It could organically grow if there was some like major thing. I'm probably going to change that when I get around to changing the nature of the channel interactivity with YouTube and Rumble. But when that happens, then that would be the time to do that. And that would be the time to kind of flip the vision of the YouTube channel a little bit and utilize it for a completely different purpose, which is in the plan, but that's a slow moving plan and requires a bunch of other people to do some things before that can happen. So, but thank you for that advice, which you don't actually want to vary your content in that way. If you ever want to grow a YouTube channel, you have to remember that your YouTube channel is distributed by an AI. And for whatever AIs are, this one is a pretty weak AI algorithm that is basically an A/B, plus minus testing algorithm. It looks for consistency in topic, in demographic appeal, in subject matter, in length, in release times, and all of that stuff. It wants consistency of format, consistency of thumbnail, because it then wants to know how to distribute stuff to people who will like it automatically so they can sell ads. Once you start to figure that out, You realize that like varying your channel up a whole bunch in like live streams versus short videos versus on-demand videos, with lengths of time going like 3 hours, 20 minutes, 5 minutes, 2 minutes, doing all that really fucks up the algorithm. It doesn't know what content you're delivering. So if you want to grow a YouTube channel, consistency of theme and topic and subject matter, consistency of duration, roughly, consistency of release schedule. The system wants to know what demographic it's selling ads to. That's the most important question for YouTube.
End quote. And then added, quote, what transpired in this litigation fell woefully short of what due process demands, end quote. Now, I don't know whether I agree or not. I'm not going to take a position on that. But the fact that someone's complaining not about the bottom line conclusion, but about the very processes that were used in the state would seem to, and that would be permitted, seems to underscore the concerns that have been raised about state power. Just wanted to give you a chance to address that because that was powerful language. Again, not disagreeing about the conclusion, but about the very fairness of the process.
Yes, Your Honor, but that language was, with respect to Justice Samore, just not correct. President Trump had a 5-day trial in this case. He had the opportunity to call any witnesses that he wanted. He had the opportunity to cross-examine our witnesses. He had the opportunity to testify if he wanted to testify. And of course, the process was expedited because ballot access decisions are always on a fast schedule. But in this whole case, from the trial court all the way up to this court, President Trump has never identified a single process other than expert depositions that he wanted to have that he didn't get. He had the opportunity for fact witness depositions. He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office.
Ridiculous.
But obviously, Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, it says, shall be disqualified from holding any office. And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about 6 years before Section 3. It wasn't meant as implementing legislation related to Section 3. And I would emphasize that by the time that Section 3 was ratified, most Confederates had already received criminal pardons.
I guess the question's a little bit different, which is if the concern you have, which I understand, is that insurrectionists should not be able to hold federal office, there is a tool to ensure that that does not happen.
There's a tool.
Namely,
He's
federal
arguing before
prosecution
the Supreme Court right
of
now.
Insurrectionists. And if convicted, Congress made clear you are automatically barred from holding a federal office. That tool exists, you agree, and could be used, but has not, could be used against someone who committed insurrection. You agree with that?
That's absolutely right, Your Honor. But I would just make the point that the framers of Section 3 clearly understood that criminal prosecutions weren't sufficient because oftentimes
Whoa. The framers of Section 3 clearly understood that criminal prosecutions weren't sufficient. How do we know this? Where's your evidence? Please cite your sources and please be clear and direct on your reasoning because I haven't seen any evidence of that in the Article 3 language. But let's see if he says fucking anything about it.
insurrectionists go unpunished, as was the case in the Civil War.
Okay.
And that the least we can do is impose a civil disqualification penalty so that even if we don't have the stomach to throw someone in jail.
Well, they had the quo warranto provision that was in effect then from 1870 until 1948, but then obviously that dropped out and hasn't been seen as necessary.
Yeah, I mean, after it dropped off in 1948, not a lot of Civil War Confederates running for office after 1948, I would imagine.
Since then. Last question. In trying to figure out.
Do you see, first of all, the guy has a shit answer. Kavanaugh doesn't care. He knows it's a shit answer. The guy basically says, well, they couldn't rely on this because they clearly understood they couldn't rely on a conviction. Well, there's nothing you got nothing to support. The Kavanaugh doesn't care. He's like, actually, they had this other provision that, they could deal with that with because they made a law. Congress enacted legislation.
What Section 3 means, and to the extent it's elusive language or vague language. What about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide, because your position has the effect of disenfranchising voters to a significant degree. And should that be something, does that come in when we think about should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
I'd like to make 3 points on that, Justice Kavanaugh. The first
Oh my
is
God,
that
why?
constitutional safeguards are for the purpose of safeguarding our democracy.
Okay. All right. Here we go. Let's just attack this whole argument right now with what Kavanaugh is saying, but not saying. And this guy probably is missing the boat. Kavanaugh is saying, what about the idea that we have a level of democracy? Now, it is a representative republic that utilizes democratic functions like a popular vote to make these determinations. This guy misses the entire thrust of that, which is that the president and the vice president are uniquely situated individuals that rely on a nationwide democracy, and they are literally the entire country choosing the representative of the country. He's going into this, while there's safeguards and blah, 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 he's going to miss the point that this is almost entirely exclusive to the president. The president is unique in this capacity in that he is the national representative, and democracy, for lack of a better word, means that the people get to pick that. And an upfront, an a priori disqualification of a presidential candidate forecloses the ability of the nation to choose their representative and their leader. There are ways to remove them, but the political will of the people is really fucking important for the president specifically. And I bet he doesn't even address that Kavanaugh is likely asking him a question related to the president specifically, more than just the general concept of an election in the scope of the insurrection clause. And if he doesn't answer this about why the president specifically shouldn't be given as an option to the people to vote, then he'll lose the argument from Kavanaugh's perspective straight out the gate. And I think he does right away here, because you have to justify how the president and the vice president are shoehorned in to the section that doesn't mention them, while it mentions every other position that it goes after and other lesser positions by specific name. Why would we shoehorn in the president and the vice president if electors for the president and the vice president are specifically named, and they're an almost impossibly narrow collection of people, because their function happens, for like 1 week at a time every 4 years. And they change every 4 years too. It's not like they're the same electors. So if they're going to be excluded and named specifically, why aren't the president and the vice president listed specifically either? And it might just be entirely based on what Kavanaugh is acting here, that the president is such a political animal and such a representative figure for the entire country that they want everybody to have the option to choose who leads the country. Because that's cool.
Not just for the next election cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way. The framers of Section 3 knew from painful experience that those who had violently broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve. President Trump can go ask Congress to give him amnesty by a 2/3 vote. But unless he does that, our Constitution protects us from insurrectionists.
Nope.
And third, this case illustrates the danger of refusing to apply Section 3 as written, because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given another chance.
See, here we go. First of all, disenfranchising 80 million Americans is a false narrative. Second of all, let me just go ahead and say this. Insurrection is not defined as disenfranchising 80 million Americans. So let's see. We'll do this. Insurrection. Oh, shit. Insurrection. Legal definition. Let's see what it says. This is boring. We need a definition of this. Insurrection defined in U.S. Code. Insurrection. Britannica. Britannica says an organized and usually violent act or revolt or rebellion against an established government or governing authority or of a nation state or other political entity by a group of its citizens or subjects. Also, any act of engaging in such a revolt. An insurrection may facilitate or bring about a revolution, which is a radical change in the form of government or political system of a state, may be initiated or provoked by an act of sedition, which is an incitement to revolt or rebellion. In the United States, insurrection against the authority of the federal government is a crime. Doesn't define it, though. Insurrection is not just this idea that you did something that some people in the country don't like, even a lot of people. Disenfranchising, which he didn't do, but attempting to disenfranchise 80 million voters, actually isn't an insurrection. An insurrection is a literal rebellion against the United States. If you've ever heard of any insurrection, find the one that is, that vote was fraud. The vote was fraudulent. I don't trust it. Don't like it. Wasn't a good vote. Not well done. Can't count. Hired too many black people, maybe. They can't count. They can't do anything. That's why it's not a good vote. It's not a wonderful vote. It's not a beautiful vote. It's not well counted. It's wrong. It's incorrect. Doing that is not insurrection. Disenfranchising 80 million voters in and of itself is not insurrection. If it was, well, maybe Biden would be insurrection. That can't be an insurrection. Now, if you suggest maybe that January 6th was an armed revolt or an open revolt or rebellion against the United States authority, maybe you get to it, but it wasn't. It wasn't in any way. So you can't get Trump participating in that insurrection because it wasn't an insurrection still. But just merely saying, well, he was going to disenfranchise 80 million voters, that does not an insurrection make.
Thank you.
Justice Barrett?
So the general rule is that absent rare circumstances, state courts and federal courts share authority. State courts have authority to enforce the Constitution, but there are certain limits to that, certain situations in which the Constitution itself preempts the state's ability to resolve constitutional questions.
Yes.
And, Tarbell's case is one, and you said earlier that once a president is elected, you accepted that a state couldn't do anything about that. Like Colorado couldn't enact its own, say, quo warranto provision and then use it to get the Secretary of State or the president or anyone else out of office. And I assume that's because of this principle of structural preemption.
Okay, so that's hilarious because this is something I've been talking about. Now, I didn't read the briefs on either side of this because they're long and boring, but here's the thing. This is something I've been saying over and over and over again. The 14th Amendment prevents someone from holding office, not attaining office. So, in theory, if an individual state can prevent a presidential candidate from being on a ballot because they're disqualified as an insurrectionist, in theory, they could enact the disqualification midterm. Therefore, I guess usurping Congress or somehow forcing Congress to impeach, which doesn't make any sense. And they argued, apparently in their brief, because that's what Amy Coney Barrett's bringing up here, that would actually be a violation of federal authority. That would be the state not having the ability to override federal authority to effectively impeach. So how do you get around this? If a state doesn't have the authority, as you say, because of structural supremacy to remove a president or to invalidate a president who is sitting while the 14th Amendment plain language says holding office. If the state can't do that, how in fuck can they prevent someone from running on the ballot when it's the same inherent authority to do either one? Actually, it's a better authority to remove a sitting president than it would be to disqualify a running president. Because again, the 14th doesn't prevent someone from attaining office, only holding it.
Right?
Yes, Your Honor.
Okay. So I just want to clarify what that means for your argument. That means that your eggs are really in the basket of the electors clause, really in the Article 1 basket, because you're saying that even though all of the questions that people have been asking have suggested that there's a problem with giving a single state the authority to render a decision that would have an effect on a national election. But you're saying that those structural concerns, which might otherwise lead to the kind of result that you would accept after someone is in office, are overcome by the electors clause.
Absolutely. States run presidential elections. That's very clear from Article 2. Once states have selected the electors and the electors have voted, states have no more power over the candidate who has been then nominated for president.
That doesn't make no sense. That don't make no sense. States have, let's just. Here we go. Here we go. Here we go. Here we go. What the fuck is this? Real quick. We'll pull this up. Here's Article 2. Executive power vested in the President of the United States of America. Boom. Shall hold office during his term. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States should be appointed an elector. So the states appoint electors. He's saying states control election. Let's see where. Electors shall meet in their respective states and vote by ballot for two persons, blah, blah, blah. They shall make a list of the persons, sign for president, blah, blah. This is all shall. Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural born citizen or a citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. In case of removal of a president from office, blah, blah, blah. President shall attack. Okay, so here we go. Next section. Commander in chief shall have power. This is it. This section right here, he says that the states get to control the election. No. This does not say anything about the states choosing who goes on the ballot and who doesn't. This doesn't say the states get the right to include and exclude ballot members. It says they get to choose in a manner as the legislature thereof may direct, appointing electors. But those electors can't be prevented from voting for certain candidates. So this is a fundamental issue with why their argument doesn't make sense.
President. But until then, the states do have the power to adjudicate those issues.
Thank you.
Justice Jackson?
So when I asked you earlier about the uniformity concern and the troubling potential disuniformity of having different states enforce Section 3 with respect to presidential elections, you seem to point to history in a certain way. You said, I think, that the framers actually envisioned states enforcing Section 3, at least in some circumstances where there were insurgents and Confederates. And I guess in my view of the history, I'm wondering really whether presidential elections were such a circumstance, that the framers actually envisioned states enforcing Section 3 with respect to presidential elections as opposed to senatorial elections, representatives, the sort of more local concerns. So can you speak to the argument that really Section 3 was about preventing the South from rising again in the context of these sort of local elections,
South will rise again.
as opposed to focusing on the presidency?
2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else. Yeah.
Understood. But the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3?
Thank
you. The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
Okay, so I see a bunch of people surprised by Justice Ketanji Brown Jackson here. And I saw the media surprised by the liberal justices all seeming to be well on board with siding on Trump on this and against Colorado. If you're surprised that the liberal justices think this way, please, please, please do something very, very important here. I know it's really tempting. It is really tempting to go ahead and just take liberal versus conservative to the Supreme Court. But the Supreme Court is way more complicated than liberal versus conservative. The issues are more nuanced. Judicial reasoning and judicial perspectives are more nuanced and more rigid than mere political positions. Now, sure, they may have general ideas about basic social structures, but alliance to political party goes only so far as their basic understanding of rights within these social structured contexts. So if you get a liberal justice, you're likely to get a liberalized opinion on something like abortion or marriage or voting access or the voting rights, things like that. You're going to find that that's a more common theme because their judicial analysis favors these sort of disenfranchised communities or populations and wants to elevate them by giving them boosts. So you'll see these rights granted in this way, and it'll start to look like a Democrat platform, but that's not quite accurate. In the same way, Republican justices focus more, or conservative justices focus on some conservative issues in the same facet. And that's why you'll see like a bunch of pro-business or pro-corporate decisions, because conservative justices are looking at this through a judicial lens, typically of favoring an idea of corporate personhood, corporate ownership, the benefit of people incorporating by free assembly into creating a larger structure with more power, authority, resources, and distribution principles to overall amplify and magnify the effect of the individual. That's just kind of a principle of the perspective that undergirds conservatism, and why you see a lot of pro-business or pro-corporation decisions coming out of conservative justices. But then you get weird stuff like when Justice Kennedy sides actually with the individual on Obamacare, which was surprising to a lot of people. Or you see, Kennedy actually siding against the U.S. government in some of the cases involving, I think it was Hamdan, the case involving a foreign combatant detained in a foreign country during the Afghanistan and Iraq curmudgeon, what was it, kerfuffle, or whatever the fuck you want to call it, clusterfuck, that's what it was, being granted actually access to civilian courts. When you start to look at Kennedy's judicial perspective, you start to notice that he really favors the underdog and the smallest party in a lot of these disputes, because he believes, seemingly, the Constitution's role is to elevate the individual and the weakest party, to always elevate David versus Goliath. And when you start to do that, you start to understand Kennedy's decisions and why he would break with conservatives sometimes and then join with conservatives on times where it seems like he would have broken in the past. That was his perspective. So again, you get these basic structures of conservative, liberal, and it's really easy to just assign that to Republican, Democrat in the way that we would assign conservative and liberal in other contexts. But it's much more nuanced than that. It's much more, and again, in a way is more rigid. And that analysis needs to go farther, and it requires a lot of study of the justices and how they approach cases and concepts. Now, some of them, of course, are going to have very rigid personal positions. Scalia, as a devout Catholic with like 97 children, he was always going to take a devout Catholic position on some of these social issues. Never going to approve homosexuality, gay marriage, anything like that. He wasn't going to do it. He wasn't opposed to the execution of people with mental infirmities, people who are minors, because he goes back as an originalist and says, no, this is what we used to do. Why would we change that now? That's Scalia's position. It's going to be that every time. It's not always going to be conservative, but a lot of those things align with conservative stuff, except on the, anyway, it doesn't matter. So when you're surprised by these justices, which look like this is going to be a 9-0 vote against Colorado and in favor of Trump. Wow, why would the liberals do this? Because that's what the media is doing. How would the liberals do this? Do they even know? Don't they realize that Trump's candidacy is on the line here? Yeah, of course they do. But this isn't a liberal versus conservative issue. This is a practicality and a very clear, like federal versus state power issue, which liberals are going to skew towards federal power. Conservatives would typically skew towards state power, so it's surprising they'd support federal power if you think of it that way. But conservatives aren't supporting Trump here. All of them are really supporting the idea that the president is an opposing branch of government in and of itself. They have to be very careful on their ability to, through the courts, and remember the Colorado decision is specifically through the courts, the judicial branch, and the lower federal versus state branch. You've got two separation of powers issues. If the courts create a rule that impacts the ability of a president to attain office, they've overstepped their separation of powers with the executive branch. So it's easy to defer to the legislature, which with what looks like a plenary authority granted by the 14th Amendment, which says Congress shall enact legislation to enforce these provisions. If they overstep that, they overstep not only judicial versus executive separation of powers and judicial versus legislative separation of powers. They go state versus federal and usurp federal supremacy and grant it to the states in a way that doesn't make sense. All 9 justices hate that proposition because it undermines it's a useless overexertion of judicial authority. It's an expenditure of their judicial capital, their perception capital, their political capital. It's an expenditure of that for no actual tangible gain because they're just going to say that the Supreme Court can create this rule out of whole cloth when the Constitution says Congress should. And they're going to give that power not to themselves, but to the states. So if you look at this as a power dynamic and a question of, does this make sense for the Supreme Court to step in and intervene here when we have clear instructions on how to do this? No, it doesn't. This should not surprise anybody. And the fact that the media is surprised by this shows that they don't understand how the Supreme Court operates, even on their political levels that they supposedly don't have. And it shows that they don't understand judicial perspectives and why these justices are where they are and what they're trying to preserve. And that's telling, isn't it? That they still don't get this. All right. WTF1A1A says recommendations to learn to be a lawyer for free in the sense of thinking and understanding like a lawyer. Look, there's a shitload of books. You can go buy, various subject books from law school coursework. You can buy Erwin Chemerinsky's Constitution book, and it will teach you all about constitutional powers versus liberties and the major case laws between it. You can read Supreme Court justices' books. Scalia's penned a bunch of books. You can do that. There's tons of YouTube videos from Yale, I think, from Harvard, from Liberty University. Well, don't watch Liberty. Law schools put a lot of lectures online. But here's the thing. You can learn to be a lawyer for free, sure. But you're not learning to be a lawyer in the true sense. You won't be able to take that and then go take the bar and become a lawyer. If you just want to learn legal principles, watch a bunch of lawyers on YouTube talk about different stuff. Not me, like real ones. Watch them, check out their analysis, check out how they approach problems, but also read law review articles, read books on speaking the language of law by Scalia and stuff like that. And then actually just get some course books. Buy the used ones on Amazon that are, past editions and out of print, and start to learn how to research law, stuff like that. But you're not going to learn how to be a lawyer outside of law school in a sense that it can be applied anywhere. It'll just help you kind of understand the thinking. But I think there are probably a bunch of actual high-level law school lectures available for free on YouTube, so you can start studying some of these subjects. That's what I would do. That's my recommendation. Patrick Stewart says, what is this civil war they're talking about? I thought it was the war of northern aggression. Lol. Well, the self-hating whites still call it the Civil War. Okay. All right, guys. Here we go. We are going to move to Rumble exclusively. There's a 25-second transition. It's really fast. Just involves a steak knife. And then we are going to go to a bathroom break for a little bit because I'm old and tired. And my prostate is I just hired Gary Coleman. He is my prostate now. I have to take a pee. And I have to go check on Lady Rackets and the little racklets and make sure everybody's actually in bed and asleep, because I tell them to go to bed right before I tell them to go to sleep right before the show because they're always still talking. So we'll check on that. If you want to pop over to Rumble, and I hope you do, click on the link in the description or in the pinned chat. We'll see you over there. We'll hit the bathroom, and then we will proceed on. There's a couple minutes left, technically 20 minutes left of this. I said there were 30. To be clear, there were 38 minutes of recording left. I don't know if all 38 minutes of those are the arguments themselves. There's technically just under 20 minutes of recording left, 19 minutes and 10 seconds or so. We'll finish that up, and then we'll go on to the other two stories for the day and see if there's anything else. If you leave and don't go to Rumble, please go ahead and click the like button if you're enjoying the content. As always, thank you for watching on YouTube and Rumble and Locals. We'll see you guys in a little bit on Rumble exclusively. Thanks for watching. Peace.